18 months ago, the conference was well underway and we had quite a lot organised. And Eugene Soltes met me at a JAR conference, it's on my left, and said, "I hear you're having a conference on fraud. I'd like to be a part of it." And I said, "Fabulous," because I knew that Eugene has a deep interest in this topic. And he has worked extremely hard to identify some very key people, 4 keynotes that we'll hear from over the next couple of days. I'm going to leave it to Eugene to introduce those people. I just want to comment on, and you'll see this, Eugene's incredible enthusiasm and interest in this topic. He has a book recently published. It is published at this point. Forthcoming, I beg your pardon. Why They Do It, Inside the Minds of White Collar. I recommend it highly. Eugene would recommend it highly, and clearly he's qualified to run this panel. So over to you, Eugene. Thanks a lot.
Well, thanks so much, Peter. And I'm delighted to introduce the 2 people that we have speaking at this panel. The first, to my left, far left, is Dr. Larry Bowers, who is the Chief Science Officer at the U.S. Anti-Doping Agency. Dr. Bowers leads the agency's efforts in research, sample collection, results management, arbitration, and education at the agency. In addition to his work at the U.S. Anti-Doping Agency, Dr. Bowers serves on the Food and Drug Administration Medical Devices Advisory Committee. He was the associate editor for the journal Clinical Chemistry and the deputy director of the drug testing laboratory for the 1996 Olympic Games. He's published more than 100 papers in the areas of analytical toxicology and drug metabolism. And I think given today's start of the Olympic Games in Rio, it's particularly timely and I think quite fortuitous that he was able to join us today. To the extent anyone's been paying attention to the news and the headlines recently, his expertise has come into, let's say, additional limelight recently. And then to my left is Professor Leo Katz. He is the Frank Carano Professor of Law at the University of Pennsylvania Law School. His research focuses on connecting criminal law, moral philosophy, and theories of social choice. In the dozens of articles in the 4 books he's published, Professor Katz has deeply explored coercion, deception, and the use and abuse of legal strategies. On a personal note, his book, his University of Chicago Press book, Ill-Gotten Gains, Evasion, Blackmail, Fraud, and Kindred Puzzles of the Law, ranks as one of the most fascinating pieces of scholarship I've ever read on the topic we're discussing over the course of this conference. He's a master at developing hypotheticals to explore some of the challenges we face in regulation. And in Ill-Gotten Gains, in his more recent book, Bad Acts and Guilty Minds, you'll find fascinating examples drawn from history, economics, moral philosophy, and religion that force one to think a little bit differently about these topics. And I'd highly recommend them to everyone here. So I'm delighted that Professor Katz is here to share his wisdom. And to the extent I think we see with this panel, 2 people from very different backgrounds, both between and among many people in the room, from athletics to law. But as I was thinking about this panel, I think as the course of this conversation will continue, I think we'll see that both of them face, as they think about regulation and some of the challenges, some similarities and I think some interesting things for us to consider in the course of financial regulation. So in terms of organization, I think given their differences in background so we better understand their work, Larry's going to begin, spend 15, 20 minutes talking about his work at the U.S. Anti-Doping Agency, followed by Leo, and then I will, although I can ask questions all day long, I'll immediately open up for questions. But if there are none, I can go and continue along. So Larry, start us off. Thank you.
Well, it's a pleasure to be here with you today. I didn't realize that it was going to be such an auspicious day with the Olympics starting this evening, but I guess it is timely. When Eugene graciously asked me to come and speak to you, I thought, well, probably there isn't a lot that we have in common. But over the first session today, I think I've realized, and hopefully you will as I go through quickly, sort of the things that we face. We have a lot more in common than we have differences. So while our mode of working may be a little bit different, the intellectual challenges, I think, are pretty much the same. See if I can. I just throw this up there because, fraud's been around, as we all pointed out, for a long time. This is from the 1904 Olympics. It's the guy winning the marathon. I don't think you'll see two people holding up the marathon runners in Rio, nor do I think you'll see them running on a dirt road like this. So sports come a long way. The interesting part is that, as I said here, this guy took strychnine, egg yolks, and brandy to keep himself going during this race. But that's not the interesting part. The guy that originally won it took a car from one place to another and crossed the finish line as the presumed winner. So even worse than the strychnine is that somebody cheated even worse, going all the way back to here. The other piece of this is I just wanted to share with you, things are changing all the time. And so 1904, the bottle on the left is a bottle of Coca-Cola from 1904. And I'll point out it had 9 milligrams of cocaine in it at that time. So, our perceptions about things change, and keep that in mind as we talk about regulation as well. I need to deal a little bit with some alphabet soup, particularly because of all the things that are going on right now. So sort of everybody thinks that the IOC is the top of the sports chain, and that's kind of true, although they really don't have any regulatory authority other than to either kick sports in or kick sports out or leave them into the Olympic Games. So for a 1 month period, every 2 years, they really have some authority. Other than that, the international federations are the ones that really hold the power in sport. They make the rules. They even do things like say, we make the rules, but if you break them, you have to handle the litigation related to that, to different organizations. So very, very unusual structure. Then there are national Olympic committees who report to the IOC. We currently have an issue with actually an Olympic committee in terms of the Russian Olympic Committee that broke one of the tenets for which they were founded, which was to enforce the doping rules, and yet the IOC, at least in my opinion, and I'm not speaking for our agency, but they failed to really do anything about that with a member organization. So that's kind of an interesting one. We'll see how that plays out in future ability to do things, regulate. The national federations, so again, if there's an international federation for track and field, there's also a national one. So you have to keep that in mind. Then we deal with the World Anti-Doping Organization, or WADA, who are really the folks who were designated the authority to harmonize internationally, and again, I'll point that out, internationally, the rules that have to do with anti-doping. Tough job. Then you have national agencies like the one I work for. And finally, we also have to deal with each nation's legal structure. So in the US, for example, there's the Ted Stevens Amateur Sports Act, which says that anything related to eligibility has to go to the American Arbitration Association. So if the World Anti-Doping Organization says, do it this way, and it conflicts with national law, we got a whole nother set of issues that we have to deal with. So interesting stuff. And then recently, or if you've been reading the paper, the Court of Arbitration in Sport is an organization that's been set out to be arbiters for any conflict having to do with the sports world, to sort of standardize things. So sorry for the alphabet soup, but if I didn't explain that a little bit, some of the other things I'm going to say wouldn't make a lot of sense. Okay, so why do athletes dope? It's sort of like, why do people cook the books? It works. That's the first thing. But then there are also a lot of coercions and incentives. For example, you think somebody else is doing it, and so you do it. And someone used the word or talked about a little bit the rationalization. Same thing occurs here. There's concern on the international stage, and justifiably, one country imposes the rules, another one works to circumvent the rules. And how does that affect the individuals that are involved? So, difficult issues. There are huge personal and financial rewards. There's immediate gratification, and this again is something I'm sure you're gonna deal with. You get the rewards for your bad behavior immediately. The penalties are way down the road, and that time discounting and the bigger that displacement happens, the more people are willing to break the rules because they figure, oh, I'm going to have a big advantage for a long period of time. The win at all costs mentality, and then last but not least, there are some countries that use sport as a way of saying my culture is better than your culture. And that's an issue. But all those things go into why do they dope, and so all those things have to go into how do we regulate those issues as well. So I'm going to ask you a question. I got into this from the point of view of being a chemist. And so one of the questions is, if we're dealing with rational behavior, how big is the threat of being caught in a totally random drug testing program, which is what I did. So if I assume what's on the board, I want to go quickly here, so I'm not going to read everything that's up there. I'll let you read and I'll talk. But if I make a couple assumptions, the person takes it a couple of times a month, it's detectable for a few days, and you assume that you're going to test 5% of the people. And again, this has no part in reality. I'm just giving you a hypothetical here for a moment. So you test 5% of the people in the pool every month. How long does it take to detect that one drug user? Anyone have an idea? I'll take offers from the floor.
100 tries.
100 tries? 9 years and 4 months. And so for us, random testing doesn't work, just like for you, random auditing doesn't work, because you just don't know when you're going to pick up the right person. So we can't do that. So you might ask a legitimate question, does drug testing work at all? And the answer is we can change people's behaviors. And I'm going to do this really quickly. The leftmost slide shows people who are augmenting their red blood cells by using a drug. We developed a test for the drug in about 2003, and you'll notice that the behavior changes. And now the behavior for the next 5 years looks like people are using blood transfusions to augment their red blood cells. And then we develop a test for blood transfusions, and now you see people look pretty much normal. Does anybody believe that people are really normal? No, they just found another way to augment things or change things so you don't catch them. So you can change behaviors with drug testing. And we've been working for the last few years on something called Perceptual Deterrence. Basically, it's a rational choice-based model. It says people do things because they weigh the risks and rewards. If the rewards are higher than the risks, they do it, and if it's the other way around, they don't. And we're trying to use general deterrence, that word came up last time, which is you catch one person and you hope 100 other people assess the risk more highly that you did that. In order to really be an effective deterrent, the detection and the sanctioning has to be certain, and that's the most important, swift, and severe. So you were talking about penalties, we do the same thing. You were talking about how long does it take to actually get the process from the time you violate the rules till you pay the price. That's something that we really have to work on, and you have the same issues. The important part is that perceptions are more important than reality. So it's what the person thinks about being caught, for example, rather than what the real odds are of being caught. And so we can do things. People calibrate their thoughts. We can interface and interact with them to cause things to happen at that calibration stage. So let's say the real odds of getting caught are 1 in 10. but if you can do things, you might convince them that the odds are really 5 in 10. And there's nothing wrong with that, I don't think, from a regulatory perspective, but you may have some questions about that. And then there's the issue of recalibration. Some people call this the cat and mouse game. The reality is that if people think their odds of getting caught are high, and they see other people cheating and not getting caught, they recalibrate and lower their perceptions about what's being done. And so what can we do to affect that recalibration? Again, that's got to be part of the process, the overall system that we're looking at using. So we've been looking at how to do things. One of the things that we've come upon is the use of both formal and informal sanctions. Informal sanctions are things like shame. So, for example, we had a policy that we wouldn't necessarily announce the name of an athlete who violated the rules. We thought about that and we said, well, you know, that's probably part of the sanction. In fact, surveying athletes, that's more important to them than actually losing the eligibility. And we actually use that, and I'll talk a little bit about that more. Formal sanctions are fines, you lost your eligibility, et cetera. So we have to use both of those. There's all kinds of things, and obviously I don't have time in a few minutes to talk about all of this stuff, but there are ways to influence perceptions. People are ambiguity averse, and so we do things like no advance notice testing. So we don't tell you when we're coming to test, we just show up anytime, anywhere, and do that kind of a test. We store samples in the freezer, pull them out when technology advances, and retest them. And if, in fact, we catch somebody at that point, they get sanctioned just like if they had been caught at the beginning. We do things like we evaluate the people who collect samples for us based on the time of day that they actually do the collections, because we found that everybody did them at the same time because they got paid for successful collections. They didn't get paid for unsuccessful collections. So they all went at times, which happened to be the same time every day, when they got collections. When we changed their reward system to say, you have to vary the times and you're going to get your bonus or whatever based on that, it changed behaviors and helped with our strategies. Anticipated regret is interesting. An example of this would be we did an educational bit with the athletes, and we said, okay, you know, sit down and write your mother or dad a letter and tell them all the things that you want to tell them, that you just made the Olympics and you're there and you want a medal, and that's terrific. And then we said, flip the page over and now write your mom and dad a note about all the things that you just got caught, you know, doping or cheating. And it's really that kind of, people don't think about that ahead of time unless you really kind of introduce that, and it's been a strategy that's been helpful for us. Obviously, the certainty of detection is the most important thing. If people think they won't get caught, the risk is very low. We need to improve the swiftness of punishment. That's a slow system in our end, just like it is in a lot of places. And we need to ensure that the system is both substantively and procedurally fair, because people don't follow rules if they don't think they're fair. They tend to write them off. And the last thing, and it's really important, and you haven't talked about this yet, but at the end of the day, this process is really athlete-driven, or should be athlete-driven. It's theirs. It's their process. And so we need to develop a values-based community that values true, clean competition. If they want that, then they should be a part of that process and help in doing that. So over the years, I sort of view the athlete community or the testing community as three parts in a pie chart. The first group, because of their values, are conformists. They don't break the rules because the rules are there, and they think the rules are right, and they don't do it because it's the wrong thing to do. The second group of people are deterrables. And those are people that weigh those risks and rewards, and you can change their behaviors based on programmatic issues. And then there's the last group that we call incorrigibles. And those are folks that don't behave in the same way. And by that I mean they might have a much higher perception of the immediacy of reward. They don't care what happens in the future. And so some of the things that you might do that would deter other people don't work with them. And so I'm not going to mention any names, but you might think of someone that might fit in that category. And we've come to the conclusion that those people we need to address in different ways. And really probably the only way to deal with them is to catch them and get them out of sport. So the challenges, again, not unlike yours. How do you create a unified program that addresses harmonized goals and outcomes, but recognizes there might be different strategies? And I'm talking internationally now. We got different cultures and maybe some things that you don't have to deal with. We have to identify sufficiently severe sanctions. If you make $25 million a year on a sports contract and you get fined $10,000, it's really not very effective. We have the same problem you do, resources. How do we need to conduct tests, we need to do things, how do we get those resources? And then staying current with the medical and pharmaceutical research is not insignificant. We've caught athletes using drugs that haven't made it through human trials yet. And so how do you find out about those things and develop ways to incorporate them into your program before the rest of the world even has a chance? So those are some of the challenges. I'll just close with really quickly. I'm starting to think that international sport is almost the ideal situation for fraud. Because if you look at international sport, they put themselves in a place where they're not particularly under any country's rules or laws, and they operate on an international scale. So it's hard to get, let's say, a national police oversight or any kind of a national organization's oversight, because this group doesn't necessarily have to report to any of those folks. A lot of these sports, there are political favors required to rise through the ranks. And so you get used to this thing that people ask you to do things for them in order for you to progress to the next level, and that's not necessarily the kind of thing that inhibits cheating or inhibits fraud. We have some cultures and countries that don't have strong ethics and values, that fraudulent behavior is a normal part of their business operation. And so they're asking the question, why are we doing this? That's the way we do things. There are huge amounts of money involved. The IOC is a not-for-profit corporation that makes over $4 billion a year. That, to me, is a little bit of a misnomer. But, they sell the rights. Not only they, but other sports organizations sell the rights to competitions. And they talk about growing the sport in new markets. And so all of that has to do with revenue streams coming in. And so, again, the opportunity and the potential is there, I think, to do things. We've got an organization, and someone brought this up, separating, maybe we don't do such a good job in sport of separating the scorekeepers and the scorers, but a lot of groups have the same financial interest, and at the same time they're regulating the people that are involved in those in cheating. We've got growing organized crime interest in gambling. And so again, you got lots of money and people not necessarily interested in doing things in the best way. So the result of all that is we've had a number of scandals in sport. We can go back to the 2002 Olympic bid in Salt Lake City, and the IOC really doesn't like the U.S. very much because they got caught up in basically vote selling issues that had to do with the site of the games. There have been a number of bribes and corruption issues involving Olympic host city venues. Rio is a great example. The money disappeared. There was $51 billion spent in Sochi, and probably almost half of that is not accounted for correctly. The UCI, which was cycling, really ignored doping for a number of years to grow the sport. That was the reason. We've had the Soccer Federation looking at bribes for locating World Cup bids, et cetera. And now the most recent one is the Russians falsifying data, which is interesting. If you haven't read the McLaren report, and it's interesting because what they did, we try to put things in place to make sure athletes are anonymized and nobody can tell whose sample's being tested. So at the location, they give their sample, the sample's assigned a number. Anything associated that would associate their name with the sample number would come to an agency like ours. The sample goes to the lab identified only by the number. So the lab has no idea whose sample this is. They test it, they report the results back. We can combine the two and even look at past results. So some of the things that were talked about in the last panel, we do exactly the same thing. Associations with coaches who've cheated before, looking at your past test result history, all those kinds of things, we use those tools as well. But what the Russians did was they had the athlete go in, give their urine sample. They came out and they said, here's my bottle number. Somebody called the Ministry of Sport, who called the lab and said, this sample number should have a negative result. And so that's the essence of what happened with the Russians on the scandal going into Rio. So anyhow, I think I've taken my time. Hopefully that was interesting. I thank you for your attention, and I'll be happy to participate in the discussion.
Thanks so much, Larry. I think as you start hearing, I think the challenges and the similarities between a corporate manager and athlete are actually not so different under these high-powered incentives and motivations. I think what's really interesting is to hear about some of the pretty creative things from a regulatory standpoint, saving the samples, trying to stay ahead, which I think probably differs in some ways from what we think of financial regulation. So thank you, Larry. And I want to introduce Leo, who will give his perspectives from law.
Yeah, thank you. Let's see, can I just close this? Yeah. All right. Well, the title of this panel is Loopholes and Fraud. And the insinuation, of course, is that the exploitation of loopholes should be thought of either morally or legally as being a species of fraud, either deserving of moral opprobrium and probably legal prosecution. The drift of my remarks will be to try to convince you that that's not so. The two don't belong together. Loophole exploitation is an entirely different sort of thing, not at all deserving of the sort of opprobrium usually cast upon it. In particular, there are three claims I'm going to make about it, all of which I suspect you're going to find lots of grounds to disagree with. Before I get to them, let's just be clear that we're thinking about the same thing when we're thinking about loopholes, although I think what I have in mind is pretty much what everybody else has in mind, but it's good to have some concrete examples. One good standard legal example of loophole exploitation is something in bankruptcy law called exemption planning. Someone is on the verge of declaring bankruptcy, but that doesn't mean that he literally doesn't have any assets, of course. He might have a lot of assets. He just has debts that exceed the assets. And if it's going to be personal bankruptcy, what he's expected to do is to give up the assets that he's got in exchange for the much larger, being liberated of the burden of the much larger debts, and then he gets a fresh start. Routine, a not uncommon practice, routine advice given by lawyers to people on the verge of doing this is to realize that when you declare personal bankruptcy, you're not literally required to turn over to your creditors every asset that you've got. You don't have to take off the proverbial shirt on your back, and there are lots of things that the law considers the equivalents of the shirt on your back, and that can include, your house, musical instruments, certain kinds of pensions, all sorts of personal effects. Those are, of course, the least controversial. So the advice that somebody might be given on the verge of bankruptcy is to move to a state that exempts a particularly large category of assets and to take whatever cash he's got and to convert them into musical instruments or pensions or a house and so on. My former colleague Elizabeth Warren tells me that when she was at a conference of bankruptcy judges, she asked them what they thought about this practice of exemption planning. Half of them thought that it was outrageous, fraudulent, illegal. Half of them thought that it would be malpractice for a lawyer not to tell his client to do this. So it really qualifies as being a pretty good exemplar of loophole exploitation, and has that nicely ambiguous quality, and elicits the ambivalent reactions that loophole exploitation in general do. Here's another example, this one from immigration law. Somebody visiting the United States develops the sudden desire to stay here, and he doesn't want to do so illegally, so he goes to a lawyer and says, is there anything you can do for me so that I don't have to go back home and queue up with every other would-be immigrant, and who knows, only decades from now, if at all, get permission to immigrate to the United States. What can you do for me? And the lawyer will say, well, I see you come from this, pretty rotten, despotic country. There's the possibility of political asylum. Well, says the man, yes, it is a rotten place, but I'm not being persecuted, of course. I've never done anything to offend the government. And the lawyer says, well, not so far. Make an appropriate pronouncement that ensures that when you get home, you'd be jailed, and then ask for political asylum. What about that? Another pretty standard example of loophole exploitation. There are other examples I could give, but I think that sort of gives the general flavor. Now, my claim about these kinds of practices is, well, there are three claims. The first, most trivially, is that, trivially though I suspect controversial all the same, is that doing this, exploiting loopholes of this sort, makes up the bulk and the essence of legal practice. That's what lawyers do. That's their raison d'etre. That's why we have them. Typically, a client comes to a lawyer and says, there's something I want to do. And it's, if I just do it, I'm going to be burdened by all sorts of consequences I don't particularly like. Taxes are going to be too high. Sanctions might loom. It might be outright prohibited, or involve all kinds of other awkward consequences I don't like. Can you make life better for me? And the lawyer will find some way of structuring or restructuring the transaction to minimize the tax burden, minimize or eliminate whatever other sanction burden there is to worry about. That's what lawyers are there for, if there'd be nothing else for them to do. So in some sense, most of what, maybe not all, but most of what lawyers do can readily be described as loophole exploitation. First claim. Second claim, why is this a mainstay of legal practice? Why is there this abundant opportunity for loophole exploitation in the law? There's a general belief about why there is loophole exploitation. The source of loophole exploitation is in general regarded as self-evident, has been regarded as self-evident for as long as people have talked about law and loophole exploitation, going back to Roman days. And yet that standard explanation, I'm quite certain, is wrong. And it's what leads us to being so suspicious of the practice. The general belief that, legal scholars forever seem to have endorsed, certainly the courts operate on the basis of, is that we get loophole exploitation because rules are imperfect. They are hard to draft to anticipate every contingency. Even if we could draft them to anticipate every contingency, they might be too complicated to enforce. So whatever objectives we pursue, the rule itself is going to fall short of, capturing that objective, and the shortfall between the rule and the underlying objective, that's what somebody capitalizes on who utilizes the loophole. Rules are over-inclusive or under-inclusive, and it's this gap between what we're trying to achieve and the rules that are meant to effectuate that goal that generates the possibility. The fact that there's the letter of the law and the spirit of the law, that divergence between spirit and letter, that's thought to be, and it's intuitively plausible, the essence of loophole exploitation. Well, it isn't so. I initially also thought this rather a self-evident source of it. What ultimately convinced me that it isn't so, or at least made it plausible, to make it convincing, more is required, but what made me doubt that the standard intuition we've got about the source of loopholes is correct, is that once you start looking around, you will quickly see that loophole-like phenomena and loophole exploitation abounds in areas in which this mismatch explanation about this gap between an ill-formulated rule and the ultimate objective between letter and spirit obviously can't be at work. What sort of phenomena do I have in mind? Well, let's start most straightforwardly with religious practices in which loophole exploitation is ubiquitous. Take something like the common prohibition on money lending in many religious practices. Now, the way that is coped with, as many of you are familiar with, is by utilizing a variety of perfectly straightforward devices to lend money for interest without offending against that prohibition. How is that done? The Jesuits used to recommend a method called the Mohatra contract, whereby the would-be borrower sold a cow for a certain price and then purchased it back for a pre-specified higher price. Lending with collateral, but not thought to violate the prohibition on money lending. Then there's the Jewish practice of an institution called the Shabbos Goy, in which you, somebody who knows more about this probably will accuse me of getting it a little wrong, but my understanding is that you can basically get around the prohibition of running your business on Shabbat by selling it to a Gentile on the eve of Shabbat and then buying it back. Now, what I find interesting about these practices, so they're clearly the sort of thing that lawyers do and advise, but if you wanted to explain it, the mismatch theory can't be the explanation. I mean, it's not a case of, God drafted this rule, he didn't do it exactly right, so I get to navigate my way around it until he redoes it. I mean, people don't feel guilty about doing this. They think what they're doing, as long as they're doing it in this way, is perfectly all right. So whatever is going on here, it's not the mismatch theory, it's something else. Take a different context in which the same problem arises. These sorts of maneuvers are also known to be rather commonplace in dictatorships. There are legion examples of how people would get around Soviet censorship. For instance, if you wanted to reprint in a government journal a forbidden Western article, a common strategy came to be you excerpted long portions of the article and you prefaced it by violent denunciations of what outrageous stuff this author was saying, and then you had to quote him at length before you could contradict him. My favorite example is an episode that happened in East Germany in the mid-1980s. There were some students who wanted to make known their objection to East German militarism, and they did it by, posting on a bulletin board an excerpt from a East German military journal called, or army newspaper called, Love Song to My Kalashnikov Rifle. Just posted that, underneath added something like, something to think about. Well, the authorities understood the intent, but nonetheless, that's what you were supposed to do. And it was a common practice to excerpt things from official newspapers and post them on a bulletin board with some sort of endorsement. And there's lots of such stuff used to go on in various autocracies. And again, the mismatch theory is not very good at accounting for that, because you'd think the autocrat doesn't much care about, giving notice or about the fact that somebody is complying with the letter but not the spirit of the law. So if people manage to get away with it, something else must be going on. Yet another context, your personal morality. Think about how you feel about lying. I assume it makes you mildly queasy, and you feel a lot less queasy if you can dissemble by being more indirect, not giving an answer, giving an ambiguous answer, giving an answer that's literally true but highly misleading. At least that's how I live my life. Makes me feel a lot better. Now, why do I do this? Because, where's the misdrafted rule that I'm trying to get around, and no one else? It's just my conscience that's being salved here. So did my conscience misdraft this rule and I'm getting around that? Makes no sense. A nice example of this I thought occurred in the movie All the President's Men. You may remember there's this scene where the reporter Carl Bernstein needs to get an extra confirmation about a certain story they're about to run about Watergate in the Washington Post, and the source he's got in the Justice Department is adamant about not wanting to, go on record or even off record in any way confirm the story. Just feels too disloyal doing that. And after sort of haggling with him back and forth for a while, Bernstein then finally says to the source, I'm going to count to 10. If there's a problem with with our running the story, suggesting that the President Chief of Staff managed some slush fund for the President, if there's a problem, just hang up, otherwise stay on. Then he counted to 10. Then he said, are you still there? The man said, yes. Okay, thank you. Now, why had he done that? Not because legally there was no particular significance to having engaged in this maneuver. At least I don't think so. I think he did it because it made him feel better. Why did he feel better? Well, for the same reason we'd rather be indirect about lying than direct. And again, it's not the mismatch theory. Well, there's a final context that I want to mention, and that sort of, I think, actually holds the secret to explaining, or at least will push us towards an explanation, might suggest an explanation for what's really going on. The fourth context in which loophole-like phenomena occur, and clearly don't have much to do with this mismatch idea, is voting. We all know that parliamentary maneuvers of various sorts, loophole-like maneuvers, are, a regular practice of parliamentary life. The best known of these, something called the Killer Amendment. There's a certain vote, there's a certain proposed piece of legislation you expect to pass. You think it's got majority support. And there's often this strategy you can pursue whereby you suggest an amendment. You know that the amendment is going to get majority support as well. The amended bill is now going to be proposed, is now going to be submitted to the entire legislative body, and it goes down in flames. This is basically a strategy known to take advantage of this phenomenon known in social choice theory as the voting paradox, whereby you can take advantage of certain odd properties of majority voting and derail something that is otherwise going to pass. Here, too, you're engaged in something like loophole exploitation, except here now, in addition to understanding that this is not a case of taking advantage of some gap between the spirit and the letter of the law, we rather clearly analytically understand what's going on. We understand that majority voting just has this logical property that you can play this kind of game with it. And what's more, we know, as a result of, that's sort of, those were all those interesting findings of voting and social choice theory. We know that this is by no means confined to majority voting. Basically, any voting system whatsoever can be tricked in this way. you have to be a little bit lucky with, I mean, it depends. You can't get to any result under any circumstances, but you can achieve a lot by just being devious in this way under just about any voting system. Well, all right, those examples are meant to convince you, or at least make plausible to you, without actually proving it, that the mismatch theory can't be the explanation for why we've got loopholes. The third claim I want to make is that loopholes are unavoidable. A legal system is going to be replete with them. We can close a few of them, move them around, replace one type of loophole with another, maybe contain a certain practice at the margins, but by and large, all legal systems are going to be studded with loopholes. Why is that the case? Well, this is another point at which this analogy to voting actually is quite helpful. We know from social choice theory that in the domain of voting, we understand that in the domain of voting, loophole exploitation is clearly ineradicable because of these odd properties of voting rules that, social choice theorists have uncovered over the last few decades since Kenneth Arrow's first famous insight on this in the late 1940s. In due course, it came to be recognized that this insight about voting, the oddities of voting, doesn't just apply to voting. That is, the initial insight of social choice theory was that whenever you aggregate the preferences of different voters, in whatever fashion you choose, you're going to get these various paradoxical results that open the door to manipulative behavior. Then in due course, it was understood that this actually applies not just in the context of somebody trying to aggregate the preferences of different voters, but it will often apply to an individual making a decision in which he wanted to take into account a variety of different criteria. Something as straightforward as, choosing between several different cars, and we can rank them by a variety of factors that are relevant to us, the price, the safety, comfort, and so on. They will, depending on which of these criteria we apply, we will rank them differently, and then we have to come up with some method for, distilling that into an overall judgment. And it was soon realized that this process of distilling these different factors into an overall judgment, well, that's not very different from what goes on in voting theory, and that therefore one should expect the same sort of paradoxical consequences and the same sort of opportunities for manipulation to surface in that context as well. Well, legal rules are ways of, what the lawyer does is play around with a variety of different rules that very much interact like the different dimensions that you take into account when you decide which car to buy. A given legal rule, when it is designed in and of itself, is a way of aggregating a variety of different values. And because in all of these different legal contexts, what's going on is an aggregation process that closely resembles what goes on in voting, the manipulability that we've come to accept in the parliamentary context, we're also stuck with more generally in the legal context. And just as it really doesn't make much sense to condemn the parliamentarian who takes advantage of this killer amendment maneuver or some related maneuver, it doesn't make much sense either morally or legally or just, as a matter of common sense. It's like rebelling against the law of gravity to try to do something about the fact that the lawyer avails himself of these legal counterparts to the killer amendment. All right, and there I'll stop.
Great. Well, thank you. I think raising some important questions that I think force us all to think a little bit more deeply around some of these issues around loopholes, which I think represent a lot of what we see in managerial behavior. So with that, I think it would be great to open up for some questions because I suspect there will be a few. Yeah. Oh.
Can I ask that you wait for the mic so that it's recorded on the video?
Questions directed to Larry Bowers. So the incorrigibles, are they predictable?
That's a great question. I suspect the answer is yes, but I don't. We've not gotten to a place where that's something that we've pursued. I suspect there are characteristics of those people that you could pick and maybe focus more attention on that, but I don't know. That's a very good question.
Larry, I have a question, and please correct me if my summary from the news from yesterday was wrong, but I think the IOC came out and said something along the lines of, if future testing proves that you were doping in these Olympics, there will be penalties involved. Do you think that will be a deterrent to any of the current athletes, or is it possibly an admission of our testing just hasn't caught up yet?
So we've been storing samples since about 2000, and we have pulled out samples and retested when new technologies develop. So there's a bit of what your question was. Is it because the tests don't work now? And the answer is yes, to some extent. Although I'd point you to the fact that cat and mouse game I talked about, you develop a test and then you see changes in behavior to try to avoid detection. So some of it is that part of that dynamicism of people trying to work at the margins to see if they can't do something that'll essentially get them around the test. So I don't think this is any different. I mean, there currently is testing going on from samples stored from London and I think from Sochi, maybe from Beijing as well. And those the rules specifically say now that we have 10 years that we can go back and retest a sample, and if it's found to be positive for something that's on the list of doping agents, then in fact the person can be sanctioned that far out. So the struggle is, we talk about that time devaluation to deterrence, and that's the other side of that coin. So while it sounds good, something that happens 10 years from now is probably not as effective in the deterrence part of the program as catching them. But for the incorrigibles, it's certainly a wonderful way to catch up with them.
Yeah. So if you see what happens to avoid financial fraud, let's say they focus on the inputs, like trying to avoid that people get into fraud, like through internal controls and auditors and whatever. There's also like an analysis of the outputs, which are the financial numbers. As they are analyzed to see whether there are like jumps that cannot be explained, and that's like kind of red flag that then like, okay, we have to analyze this case more in depth. If you see what anti-doping agencies are doing, they're mainly focusing on like inputs, trying to avoid that people take things you're not allowed to do. But like based on my experience in sports, it's like quite, or let's say not too difficult to predict performance. You sometimes see jumps in performance, especially in some disciplines. It's quite easy, like swimming, track cycling, track running. Is the anti-doping agency also like analyzing the performance of people and using like if you see unexpected things there and then using that as a kind of red flag to analyze cases, or is that allowed, or
This sounds like the revealing the sauce question from the last session. And so I'm not going to reveal all the sauce, but I will say that performance associations with individuals all of those things go into tips from athletes. Actually, the most recent thing that resulted in a new compound being added to the list was the result of tips saying that people were traveling to the eastern part of Europe to get special treatment. And so, you know, the next step in the investigation was, well, what's involved in the special treatment? It took a bit of time to get everything together, but yeah, that resulted in identification of a substance we hadn't known about previously, and eventually a bunch of positive cases. So we use all kinds of information.
But it's really like, you know, you have a swimmer and you follow him and you just record all his performances. It's like a kind of panel data set you have. You run kind of regressions, whatever on it, and then I think.
Yeah, like I said, without revealing the sauce, we look at a lot of long-term, not just performances, but biochemistry and other things as well. So
gold, in other words, gold medals immediately profile you for make you a suspect.
I didn't say that.
I'm going to interject one question, and just as I hear this, I guess the dichotomy in the different conversation is that a lot of the challenges it seems like that the U.S. anti-doping agency is trying to address are things that are loopholes. I mean, ultimately, we saw something about red blood cells, people taking a drug, you forbid that particular substance, then people start transfusions, you figure out a test for that. And so I'm going to now to Leo's comments about the sense inevitability that some of these loopholes are created within not just a legal system, but obviously any regulatory body. So how do you think of, so I guess in both cases, I want to both of you, how do you think about actually designing regulation in the face of, to the extent I'll take some of the premises that you've made as true, that loopholes are inevitable?
Yeah, I mean, I would expect, and I'm kind of curious if you've encountered this. I would have thought that there are all kinds of practices where the challenge for you is not so much ferreting it out, but dealing with the fact that you find it inherently, although you're not unhappy about it, you find it inherently repugnant to do something about it. I mean, for instance, somebody undergoes a certain medically necessary operation that perhaps you might not have undergone, but for the fact that there's a collateral benefit to, to the transfusion that will accompany it. There are all sorts of extremely antecedent measures that someone can take in which one variable for him will be if there are certain advantages to his athletic performance. Now, in general, we can't say you shouldn't have an operation if it has advantages to your athletic performance. So, don't have that leg repaired because it would help your athletic performance. However, simply conceptually trying to draw that line, never mind finding out whether it happened, I would think would be a not infrequent puzzle for the regulator.
Yeah, so we've talked about one small piece of what we do. We recognizing that there are therapeutic things that need to be done. There is a process to get an exemption from the rules for a process. And so the question is, you gather a group of experts to evaluate whether or not you've met the criteria to get that procedure. And if you did, you're given permission to do it. And if you're not, you'd be advised not to compete.
Mm-hmm.
I'm trying to tie this back to our situation here with financial reporting and particularly earnings management. A lot of interesting issues arise. I'm particularly interested in Larry's point about the recalibration and the cat and mouse game. And I imagine in sports there is a whole almost underworld industry which is trying to beat what you're doing. There's labs, I presume. There is connection between agents and labs. And I'm wondering whether in our context, to what extent there's an underworld industry also, particularly in earnings management, and who would be the actors. This is not a question for this panel, it's really a question for the previous panel, okay? I don't know if Greg is still here, but who are the people who actually advise you, if you want to do earnings management, how to do it? As Trevor indicated, we have a system of compliance with GAAP in our auditing, and as long as you meet the rules, you can, it's okay. What Leo said, it's actually what a lawyer's for. They're actually there to tell you how to create the loophole. What are accountants for? They're there to tell you how to deal with the loopholes. And I believe there was instance of accounting firms in the boom in the late 1990s of actually writing white papers to show how you could actually recognize revenues and so on through these capacity swaps with telecoms. Trevor will tell you a bit about it. To what extent, this is for the previous panel really, or for discussion in the room, to what extent is there an industry that actually helps management deal with these loopholes, like a lawyer, and to what extent the accounting firms, the auditors who the PCAOB is watching are actually involved in this, what we would call in the old days, form over substance type of advice.
I'll jump in.
Okay, sure.
So my view has been that one of the things that I really wanted to get my hands on when I was at the SEC, and it was one of the reasons why I actually reached out to the PCAOB originally, was I believe that audit partners develop reputations for letting things slide. And I believe that you can establish that reputation, and you will find that clients who are more inclined to want to cook their books are going to seek out an auditor who will be complicit in that. And so I thought it would be really interesting to get that PCAOB data that talks about who the specific audit partners are on engagements and to see how that actually correlated with fraud. So that was sort of my underlying hypothesis on how it might work its way through. But since I have the mic, I wanted to ask a question.
One more comment, and then maybe then question. Yeah. Comment?
You can now start doing that research because the PCAOB has a rule that goes into effect in another year, this year, and it will disclose the name of the engagement partner. So I'm sure we will be getting a lot of this type of research.
So the question I wanted to ask was, when one of the concerns that we have, right, or I had, when you're trying to detect accounting fraud is this issue about the rate of false positives, and that came out in some of our discussion this morning. So I was wondering, how reliable are the testing procedures, and do you face similar issues with the tests that you employ generating false positives and maybe unfairly identifying an athlete as a doper? And this seems to be particularly relevant when you're going back and looking at past samples where you can't actually resample to see whether there was something wrong.
Yeah, good questions. The reliability of the tests is really very good. I mean, you can never design a test that's perfect, but the tests are very, very good, and there are replications in the testing that, I mean, you can't just do it once and have it be a positive case. You have to do it multiple times and show that you get the same results. And that's actually done. One of those instances, it's done with an athlete and/or a representative of the athlete present to see the testing. So, and then of course we have the whole legal process or arbitration process to go through where people have, introduced things like, any imaginable explanation for the test results that you might come up with, including the test is a bad test, and we've had to defend against all of those assertions. I don't know. One of the other benefits of stored samples is that there might be more than one stored sample from an individual. And so again, we've not actually gotten to the point yet where we've done that, We had one case, I can tell you, that the initial result was very suspicious, caused us to go back and retest the individual a couple of times, and it was actually the time sequence of the results from the tests that eventually resulted in the person's being convicted, if you will, of the doping violation. I think if we had had any one of those tests and not the others, they might have gotten away with it. So there are a number of different strategies we use to try to address those issues.
I have a question for Leo. Now, I read the book, Richard Posner's Economics of Justice, many years ago. I was very impressed by it, and he gave me the feeling that he could explain a lot of laws as kind of the working out of self-interest, and it led to a form of economic efficiency. And as I listened to you talk about loopholes, I sort of had the same feeling about loopholes, that they too were the reflection of some kind of working out of some form of economic efficiency, like the ways of getting around the anti-usury laws, for example, actually lead to a better economic outcome. So my question is, how much of loopholes can be explained as working outs of this? And if you look at the case of bankruptcy, for example, it occurs to me that bankruptcy is a loophole that is actually built into a debt contract. And it's there because bankruptcy gives people the chance to rewrite all their contracts. When something changes, you need that flexibility built into the system, and loopholes just may be another form of flexibility that end up encouraging, in some perverse way, efficiency with lots of mistakes. That's my question.
I mean, that's certainly sometimes true. I don't think it describes the loophole phenomenon generally. I mean, sometimes it's a fortuitous thing, and there may be the way we don't like the working of a particular rule, and so if people find ways to circumvent it, that makes us happier. But most of the time, I think our reaction to loopholes is rightly a more ambivalent one. The best illustration for me of that sort of ambivalence is entirely outside the financial context. Maybe you know the movie Death Wish, 1970s movie involving Charles Bronson. He decides to avenge himself on the criminal element of New York because his family was the victim of a violent crime. So he goes to Central Park in the middle of the night, looking like a vulnerable tourist, sort of bills peeling out of his back pocket. And then as soon as the inevitable assault happens, well, he's got the gun and is ready, and he mows down the assailants. What do we think about that? The movie is sort of built on the unambiguous premise that he was an illegal vigilante. But actually it's entirely unclear what to do with this well-known criminal law category of the provoked, somewhat contrived case of self-defense. It's sort of a loophole in the law of homicide. Now, what do we think about somebody contriving to create a situation of self-defense? Clearly, there are some situations where this sort of contrivance, we think about them and we think, the person who goes into a bar, there's his worst enemy, he keeps goading him until that person lunges at him and then he uses deadly force to kill him. It can't be that we grant him a self-defense right. On the other hand, there are lots of other contexts. Somebody goes into a part of town where he perfectly anticipates that he might have to use deadly force and he's ready to do it. What do we want to say? He can't do it either. And the Charles Bronson case is sort of nicely in the middle there. We're not thrilled about the contrivance. On the other hand, even when we're aware of the fact that it is a contrivance, we're really quite torn about. The fact is, he's entitled to be there in the middle of the night. He was assaulted. He is acting in self-defense at the very moment. Yes, he did anticipate it, and there have been all sorts of attempts to try to define and distinguish between the contrived cases of self-defense where the contrivance doesn't deprive you of the defense and where it does, but ultimately ultimately one is going to be stuck with some such cases of contrivance in the law of self-defense. And it's not that we particularly think that it's desirable for someone to get around the law of self-defense. It's that there are other things that inhibit us from saying, declaring it out of bounds. And lots of contrivances and loophole cases are like that, as opposed to like the usury case.
I think we have time for one more question. I know this side's been quiet. This side, all the way in the back. Great.
I don't have a microphone, but I can talk loudly. So, also for Professor Katz, so I heard you say that the mismatch theory doesn't work. Mm-hmm. And then in response to Don's question, which stated better than me the question I wanted to ask, it sounds like you were rejecting an efficiency story for loopholes. Do you have an alternative theory for loopholes? And in your response to Don's question, I sort of heard a Ronald Coercion kind of conjecture that the law sort of bumbles its way toward efficient outcomes because there are so many ambiguities that cannot be specified ex ante in law or contracts. So there's a lot of ex post settling up of these ambiguous situations that lead us generally in an efficient outcome. Is that what you're proposing?
No, I mean, my suggestion really is that something that has come to be generally accepted about parliamentary procedure actually extends more generally to law. So of course there's, what individual people do is motivated by self-interest. And there is the larger question of whether we're in a situation where the interaction of self-interest, as it often does in a market, leads to an efficient outcome or not. And on that I have no pronouncement. My more modest claim was that we get into the situation the same way we get into it in voting. It's logically inherent in a voting context that when we have a method that aggregates lots of different voters' preferences, we've created opportunities for this sort of manipulation. Whether these opportunities in the end work out for the best or not, I think in the voting context, sometimes they do, sometimes they don't. And the same, I think, is true of legal rules more generally. They are inherently subject to this sort of game playing in the same, we can try to fix it here or there, but just as we wouldn't be able to fix it in the voting context, we can't really expect to fix it here too. Whether it's for better or worse, kind of like asking whether the law of gravity is for better or worse. It's just a fact with which we then have to work.
Great. Well, I think we're out of time, but I know there's more questions, and I know they'll be around later today that I am sure continuing the discussion. So I want to thank both Larry and Leo for generously taking the time to speak to us.